Hello and welcome back to our channel. If you are new here, welcome to SOLegalNG. On this channel, we discuss core law topics and offer effective study tips and hacks to help you excel as a Nigerian law student, as a law student in general. In today's video, we'll be talking about one of the core pillars in Nigerian constitutional law or in the Nigerian legal system. And this is a topic that you would typically come across as a 200 level law student in any Nigerian university, and it's the hierarchy of courts. This is so important because you come across it throughout your study of law, and even in practice, it will affect what courts you go to, at what points, for what cases. So let's dive into that right away. So in Section 6 of the Nigerian Constitution, we find the foundation of the Nigerian judiciary. And Section 6 sub 1 vests the judicial powers of the Federation on the courts. And then under Section 6 sub 5, we find a list of the superior courts of record in Nigeria. And this hierarchy that we find under Section 6 sub 5, it essentially dictates how appeals flow and determines whose judgments bind whom. So let's build on this hierarchy. We'll take it as a pyramid starting from the top down. And at the top of this pyramid is the Supreme Court, the apex of the judiciary in Nigeria. Section 230 of the Nigerian Constitution establishes the Supreme Court of Nigeria. And by virtue of that, the Supreme Court of Nigeria is the highest court in the land. Its decisions are first final and it cannot be appealed to any other body. And there's the popular case of Adegoke Motors Limited and Adesanya, where Justice Oputa famously said that we are not final because we are infallible, rather we are infallible because we are final. Such a beautiful quote stating how the decisions of the Supreme Court are final, and that is what makes them supreme. There are two types of jurisdiction that the Supreme Court exercises. It exercises original jurisdiction, and by original jurisdiction we mean the jurisdiction of a court to entertain a matter the first time. Like the first time a matter is brought before the courts, what courts can hear that matter? The Supreme Court, under Section 232 of the Nigerian Constitution, has original jurisdiction to hear matters concerning disputes between a federation and a state or between states. So only when there is a dispute between the federation and a state, or there's a dispute between two states or among states, then the Supreme Court has original jurisdiction to hear that matter by virtue of Section 232 of the Nigerian Constitution. However, the Supreme Court also exercises appellate jurisdiction, which is a very common, or the more popular jurisdiction that the court exercises. It is the superior or the supreme appellate court, in the sense that appeals from the Court of Appeal go to the Supreme Court. Now, once the Supreme Court makes a decision, that decision or that judgment becomes binding on every other court in Nigeria, because it is the Supreme Court that the apex of the hierarchy pyramid. While we talk about hierarchy, it's also necessary to know the quorum of the court. So when the court is sitting to exercise its original jurisdiction, or if it is interpreting the Constitution, or it is dealing with fundamental human rights, under these circumstances, the Supreme Court will be properly constituted if there are 7 justices. So they have to sit as a full court, 7 justices, to hear matters such as those. But when the Supreme Court is exercising appellate jurisdiction, then it is properly constituted if 5 justices sit. So that's it for quorum. 5 justices when it is appellate, when it's exercising appellate jurisdiction. But when it's exercising original jurisdiction, if it is interpreting the Constitution, if it is dealing with the fundamental human rights matter, then the court will be properly constituted only when the full panel of 7 justices sits. Now let's talk about overruling itself, because we said that once the Supreme Court makes a decision, then all other courts are bound by it. But can the Supreme Court make a decision or a judgment and then go against that judgment or go back on that judgment? Yes, it can. And this aspect is usually examined a lot of times under Nigerian constitutional law or Nigerian legal system. This question like this comes up all the time. So There is the doctrine of stare decisis, which is the doctrine that makes decisions of higher courts bind lower courts on facts that are similar. And this doctrine also makes the decision of the Supreme Court binding on itself. However, there are cases where the Supreme Court will need to overrule its previous decisions. And an example, as in the case of Johnson and Lawanson, an example would be when the Supreme Court has to do that overruling, such as to prevent an error from happening or an injustice from happening. According to the courts, the Supreme Court is final, but it is not a slave to its own mistakes. So it can't overrule itself to correct mistakes. Let's take a look at that a bit closer. What exact situations can the Supreme Court overrule itself? We'll talk about 5 now. And the first one is when the previous decision was given par incuriam. So par incuriam means by error, without giving much thought. It could also mean through lack of care or in ignorance. So if there is a case before the court and the Supreme Court in considering that case, it notices that, oh, there's a precedent, there's a previous case having the similar facts that we've already gone through and given a decision on. But on closer look at that decision, they find that there was a relevant statute that wasn't considered, or there was a clear constitutional provision or a binding precedent that was totally ignored in giving that previous decision. And if they had considered that constitutional provision or that binding precedent, or they had considered that statute, for instance, then the decision that they had given would have been different. Then in this present case, the Supreme Court can decide to overrule itself. Given that there was this relevant law that was ignored in the previous case, we are now considering that law and we are giving this different decision. So that is one circumstance under which the Supreme Court can overrule itself, when the previous decision was given par incuriam. The second situation or circumstance that would warrant the Supreme Court overruling itself is when the decision is erroneous or even unconstitutional. So if the previous decision was made because a statute or a provision of the Constitution was wrongly interpreted, leading to the previous judgment, then the Supreme Court can overrule itself to bring the decision to be consistent with the provisions of the Constitution. So remember the case of Johnson and Lawanson. That is another example that works here. The Supreme Court in that case overruled its previous decisions regarding the interpretation of Section 129 of the Evidence Act. In that case, Justice Coker stated that when the court is faced with the option of perpetrating an incorrect judgment that would impose hardship on future generations, it must reverse itself. So if there is an incorrect judgment that its subsequent application would continue to cause hardship, then on the strength of Johnson and Lawanson, the Supreme Court must reverse its judgment or overrule itself. The third situation that would warrant the overruling of itself by the Supreme Court is when there is a need to prevent the perpetration of injustice or hardship. If you don't take care to see the fine lines, you would think that these are all the same points. But the first one we said was when the judgment was given par incuriam. So that's a bit of carelessness, we could say loosely. The judgment was given without considering some relevant authorities, par incuriam. Then the second one we talked about was when the decision is erroneous in law or unconstitutional. So this time they did consider the law, but the interpretation of the statutes or the interpretation of the law was inconsistent with the provisions of the Constitution. So that's a bit different from the first one. And now this third one is preventing the perpetration of injustice or hardship. So in this situation, the Supreme Court could find that if they follow the previous decision, there may be substantial hardship or injustice in that case, or the case is of such a nature that while it looks at face value that they should follow the previous decision, if they indeed follow the previous decision, it would perpetrate fraud in that particular case. And so if such a thing happens, the Supreme Court may overrule itself, may depart from the previous judgment and give a new holding, a new decision, just so that justice will be served in that case. And the case of Bucknor-Maclean and Inlaks Limited is an authority on this point. In that case, Justice Adegoke noted that while precedent is an indispensable foundation of the law, there are times when a departure from precedent is strictly necessary in the interest of justice and the proper development of the law. So Idimbe is saying precedents are great. Precedents should be followed. They are indispensable. They are wonderful. But there are instances under which for the sake of justice to prevail, for the sake of the law to be properly developed, you may need to derogate, to move or depart from precedent. The fourth situation that would necessitate the overruling of itself by the Supreme Court is when there are conflicting decisions of the Supreme Court. So sometimes, somehow, the Supreme Court will have a similar set of facts before it, and in one case it would have ruled A, B, C, whereas in the other case it would have ruled X, Y, Z. And now in a third case, currently before the Supreme Court now has to consider its previous conflicting decisions on that same matter. In that case, it will have to resolve the conflict. Which one should we follow going forward? Typically, the Supreme Court will now need to overrule the one in error or the older decision and adopt the one that is more legally sound to restore some form of certainty to the law. In the case of conflicting decisions of the Supreme Court, the sitting panel of justices will need to consider which decision will be followed going forward. Another situation is when there are changing social conditions or the development of the law necessitates an overruling. The law is not static, it's flexible, it continues to evolve, and society changes as well. So as society changes, the law has to adapt to follow those changes. So if there was a decision that was held so long ago when a certain state of societal affairs used to exist, but now those things no longer apply, the society has changed well beyond those societal issues, then the Supreme Court may need to overrule its previous decisions to meet current societal conditions or circumstances. And an example of this would be the case of Odi and Osafile. Lastly, when the previous decision was a nullity, then the Supreme Court would set aside that previous decision. So this time, it's not necessarily an overruling, but it's pretty much the same results that it has. So if a previous judgment of the Supreme Court was fundamentally defective, let's say, for instance, there was some form of fraud that was involved in the case leading to that judgment, or say the Supreme Court, in giving that judgment, did not have the jurisdiction in the first place, or the court wasn't properly constituted when the judgment was given, then that judgment in itself is a nullity. And so the Supreme Court, in a newer case, having that similar set of facts, can set the previous decision aside and go ahead to propound its own decision. So that's it for the Supreme Court. We went through its jurisdiction, its establishment, its jurisdiction. We went through the situations under which it can overrule itself, and we did talk about the quorum as well. Now we're going a bit down the pyramid to the Court of Appeal, which is established under Section 237 of the 1999 Constitution. So if you are currently offering constitutional law, then a tip for you would be to try to memorize the sections. You have to really, so in your study notes, you could put the section. One thing that helps a lot of law students, a technique that we teach, is to do it in order. So for instance, 230 establishes the Supreme Court. The next section you may want to notice 232, original jurisdiction. In that order, you don't want to do 300 and then go to 100 and then go to 50 and then go to 4 and then go to 237. It's a bit scattered and a lot more difficult to remember. Except you have very good eidetic memory where you can just see it. You can see all the sections and you just know that, oh, this is what this section talks about. If you don't, try and order the sections in the order in which they appear, and then you could do a little bit of addition and subtraction back and forth. So, for instance, 237 establishes the Court of Appeal, and 239 gives original jurisdiction. So that's 2 sections later. 239 gives original jurisdiction. The next section, 240, gives appellate jurisdiction. 7 sections later, in section 247, then it provides for the quorum. That's a bit of an easier way to arrange things, keep things arranged in your head. It helps a lot of students, and thought I'll drop that in. So back to the hierarchy. The establishment of a Court of Appeal could be found in Section 237, and the Court of Appeal is an intermediate appellate court. So it is the intermediary between the High Court and the Supreme Court. Just like the Supreme Court, the Court of Appeal has both original and appellate jurisdictions. Its original jurisdiction relates to election petition matters regarding the election of a president and a vice president. So once an election petition is being made after a presidential election or the election for a vice president, it just goes straight to the Court of Appeal. For its appellate jurisdiction, we find in Section 240 that the Court of Appeal is empowered to hear appeals from the Federal High Courts, the National Industrial Courts, the High Courts of the States and the High Courts of the FCT, the Sharia Court of Appeal and the Customary Court of Appeal. The decisions of the Court of Appeal are binding on the courts that are below it. Obviously, it's not binding on the Supreme Court because the decisions of the Court of Appeal are subject to appeal to the Supreme Court. As for the quorum of the Court of Appeal, under Section 247, we find that the Court of Appeal must sit with at least 3 justices. But if it is a constitutional issue or if it is a fundamental rights issue, then the proper quorum or the proper constitution of the court would be 5 justices. So we've done the apex court, the Supreme Court, we've touched the Court of Appeal, which is the intermediate appellate court, and now we're going to the Court of Coordinate Jurisdiction. There are a couple of courts in this same tier, and they do not bind each other. They are merely persuasive among themselves. They do not send appeals from one to another. All of them are on the same tier, and they all appeal to the Court of Appeal. So, Courts of Coordinate Jurisdiction. Here we have the Federal High Courts, we have the State High Court and the High Court of the FCT, and we have the National Industrial Court. The Federal High Court was established under Section 249 of the Constitution, and under Section 251, it provides extensively for the jurisdiction of the Federal High Court, exclusive jurisdiction over specific federal matters, including revenue of the federal government, taxation, maritime, aviation, intellectual property, mining, banking relations. So there are very specific matters relating to the federation that have to go to the to the Federal High Court. These matters have no business being in the State High Court. The State High Court does not have jurisdiction to entertain cases relating to these matters. The State High Court and the High Court of the FCT, they are pretty much the same thing, just that the High Court of the FCT is in the FCT. So it operates like the High Court of a state, and they're established under Sections 270 and Section 255 for High Courts of the State and High Court of the FCT. For their jurisdiction, we find in Section 272 that the State High Court has a very broad residual jurisdiction. So matters that are not exclusively belonging to the Federal High Court go to the State High Court and the High Court of the FCT. And so any matters that are not specifically set aside for specific courts, like the Federal High Court and the National Industrial Courts, go to the State High Court or High Court of the FCT. So for instance, simple contract matters, land matters, criminal cases would go to these courts. And this is an area that examiners love to examine on the difference between the Federal High Court and the State High Court when it comes to jurisdiction. So it's very important to note the distinction between them in terms of jurisdiction. In the case of Bronik Motors Limited and Wema Bank, the Supreme Court clarified that the Federal High Court is a court of limited jurisdiction, very limited jurisdiction. And here's a scenario that usually highlights the thin line of difference, or the confusing line, I'd say. If a bank sues a customer, let's do that way. If a bank sues a customer for a simple debt, the customer owes the bank, then that matter is a simple contract case. Where does it go? If you guess the State High Court, you are correct. So just because banking regulations were stated in Section 251 as an exclusive jurisdiction of the Federal High Court doesn't mean that all matters relating to banks would go to the Federal High Court. Banking regulations are not banking activities. So a simple contract matter between a bank and a customer, or a bank and another bank, the bank paid for some items, maybe delivery of tiles, for instance, and the supplier failed to deliver and the bank sues. That's not a banking regulation matter. It goes to the state high court. But when it comes to matters that actually touch regulations, say something regarding how money should be deposited, or BVN, or deduction of monies, regulations, then you go to the Federal High Court. So it's important to refer to Section 251 to see what is the strength, what is the extent of the jurisdiction of the Federal High Court. It will help you when you're answering questions regarding jurisdiction, hierarchy of courts, and other, just generally in your study of the law and in your practice of the law. Another court of concurrent jurisdiction on the same line with the Federal High Court and the State High Court and the High Court of the FCT is the National Industrial Court, which is another court of limited jurisdiction. It's a highly specialized court. The purpose of the court is very limited, and it is regarding labor matters, trade unions, and industrial relations. So this court was made a superior court of record by virtue of the Third Alteration Act of 2010. So you can find its jurisdiction under Section 254C of the 1999 Constitution. Now, also on this coordinate level, Apex Court, Court of Appeal, we talked about the courts of concurrent jurisdictions, we've mentioned them, but also on the side of these courts, we have courts that have their jurisdiction is limited to personal laws. So there's a Sharia Court of Appeal, authority for these courts, Section 260 and Section 275 of the Constitution. And we also have the Customary Court of Appeal, Sections 265 and 280 for the courts. So after the concurrent courts, the next, down to the base of the pyramid, we have the inferior courts or subordinate courts. Now, we do not exactly find these in the Constitution, but they were created by the various state houses of assembly by virtue of the powers given to them under Section 6 sub 4 and Section 6 sub 5 paragraph K of the 1999 Constitution. And here we have courts like the Magistrate courts, the district courts, that we'll find in the north for civil matters, and the customary courts and the area courts. These courts happen to handle bulk of day-to-day legal disputes, like minor criminal offenses, simple contracts involving low sums of money, landlord and tenant disputes, small debt recoveries. These go to these inferior courts. And because they're inferior courts of record, their decisions are subject to appeal at the High Court. Or for the customary courts and the area courts, they appeal to either the customary courts of appeal or the Sharia courts of appeal. So that's pretty much it for the hierarchy of courts. We went from the top and we just arrived at the bottom. And the reason why the decision of the top applies to every other court below it, the decision of the Court of Appeal, every other court below it, state high courts, not binding on its concurrent courts, but is persuasive on the other courts that are on the same tier with it. The reason why all of this works is because of the doctrine of Stare Decisis and judicial precedent. Really, that's how it works. So a lower court is bound by decisions of a superior court in matters of similar nature or facts. But since courts of coordinate jurisdiction do not bind each other but are merely persuasive, if there are conflicting judgments given by courts having concurrent jurisdiction, then the best way to resolve the conflict would be to go to the Court of Appeal, where a binding precedent can now be laid. And yeah, that's pretty much the basics for hierarchy of courts. The principle of judicial precedent. It works because there's a hierarchy. There's a Supreme Court and there are lower courts that are bound by the more superior courts. Understanding this hierarchy is just so important because, again, it works in exam settings. It will help you understand jurisdiction. It will help you understand where to commence an action, where to go if you lose, and which cases you can use if you're preparing for, a case. If you're preparing for a matter, if you're preparing a matter for your clients, which cases can you rely on? Can you expect the courts to rely on in order to earn you a decision in your favor? So hierarchy of courts is very important. If the breakdown in this video helps to clarify the hierarchy of courts, even just a little bit, then be sure to like this video, subscribe to support the channel, and turn on your post notifications so that when we put on more explainer videos like this, you don't miss it. So let me ask, if the Supreme Court makes a judgment in error, how does it correct that mistake? Leave your comments, leave your answers in the comment section, and let's see how well you understand the hierarchy of courts. And we'll see you in our next video. Bye.